we've got me mic this way.
In the middle.
In the middle.
Yeah. It's good to see. Ladies and gentlemen, welcome to the National Constitution Center. Hey, come on, it's Monday morning and we're back in person, and it's so exciting to see you all here in Kirby Theater. Friends, let's begin, as always, by inspiring ourselves for the learning ahead by reciting together the National Constitution Center's mission statement. Here we go. I know some of you know it by heart. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people on a nonpartisan basis. Excellent. I knew you could do it. We're honored to be joined today by members of the Federal Judicial Center. That is the organization that brings together federal judges for learning and education. And I'm so grateful to our friends at the Federal Judicial Center, including John Cook and Clara Aldman, for this great collaboration. We've done it for years, and it's marvelous to start it up again and be back in person. Those of you who are judges and visiting the National Constitution Center for the first time, I'm excited to involve you in our important educational mission. We have a marvelous education effort across the country, in person and online. Our honorary co-chairs, Justices Gorsuch and Justice Breyer, lead this, and we have judges from around the country who engage with us to offer classes, both live online using Zoom and also videos. And we've got an incredible new partnership with Khan Academy, which is the online education provider, to create a Constitution 101 class for high school and middle school kids. And it would be very exciting to involve you in those efforts. So as you spend your day here, think about ways that you might become involved, and much looking forward to working with you in the urgently important effort of nonpartisan civics education. Friends, we've got three great panels this morning, and we're going to begin with a dream team of Madisonian scholars. Both of them brave the elements to be here, and how exciting to be joined by Jack Rakove and Mary Bilder to talk about Madison and judicial review. I just can't imagine a better team to learn from. Let me introduce them, and then we'll jump right in. Mary Sarah Bilder is Founders Professor of Law at Boston College Law School. She's the author of 3 books, including the definitive and wonderfully titled Madison's Hand, Revising the Constitutional Convention, the Transatlantic Constitution, Colonial Legal Culture and the Empire, and most recently, Female Genius, Eliza Harriet and George Washington at the Dawn of the Constitution. And Jack Rakove is William Robertson Co-Professor of History and American Studies and Professor of Political Science and Law at Stanford. He's the author of many definitive books as well, including the wonderfully titled and invaluable Original Meanings, Politics and Ideas in the Making of the Constitution, also Revolutionaries, A New History of the Invention of America, and most recently, Beyond Belief, Beyond Conscience, the Radical Significance of the Free Exercise of Religion. Mary Sarah Bilder and Jack Rakove, I've learned so much from you. It's really a thrill to be able to talk together. And we're here, we have a big topic, and we're gonna shed some light on it. And that's the question of judicial independence at the founding. And there are many places we could start, but let's start with Madison, because you've both written so powerfully about him and he'll ground things. Jack Rakove, you've talked about Madison's unique theory of judicial review, which changed over time. Tell us about it. How did Madison understand judicial independence?
Well, my starting position for thinking about Madison is first and foremost to think about Madison as the framer of the Constitution. So coming to grips with what was, I think, the most creative period of his political thinking from roughly about the summer of 1785 down to the Constitutional Convention, and then working his way through the ratification struggle. And if you want to conceptualize Madison's ideas of judicial independence at that formative moment in the adoption of the Constitution, I think you'd want to emphasize at least these points. First, Madison's thinking in general was driven by the belief that whichever institutional government represented the people most directly would be the most powerful and the most potent. So that always meant at the state level, the lower house of assembly, and with the new federal Congress, the House of Representatives was the one institution you'd have to worry the most about. And I think Madison's ideas about judicial power were driven by his concerns with the nature of political power in a modern republic, where the people themselves would be able to express their preferences and their beliefs and also their prejudices through the political system. So I think when Madison thought about judicial power at the time when the Constitution was adopted, I think his first concern, and this should sound somewhat strange to a modern audience, was that most lawmakers would be amateurs. They would come and go. They would not be veteran legislators. They would not have much experience. They would not really know how to draft statutes. And so when Madison started setting up his agenda for Philadelphia, he drew upon a curious provision in the New York State Constitution, which had created what was called a council revision, which consisted of the governor, who was properly elected, and some set of members, a couple of members of his council, then some members of the New York State Supreme Court. And he wanted this body to have a limited veto, a limited negative on legislation. Meaning that while legislation was pending, a joint executive judicial council would be able to review it. And his concern here was, if you start with the assumption, which is empirically was really quite a valid assumption, that most lawmakers would be amateurs. He felt there would be a net improvement in the quality of legislation if you involved judges early in the proceedings rather than wait for cases to arise under the ordinary rules of jurisprudence, so the cases with constitutional implications would come to them in due course somewhere down the road as controversies arose. Madison, in a sense, had a kind of trade-off theory. I think if we want to think broadly and deeply about some initial understanding, or at least an initial conception of judicial independence, Madison, in a sense, was playing somewhat fast and loose, or at least was playing somewhat liberally with the ideas of judicial independence that the framers had inherited. Both from certain principles of the British Constitution in the 18th century, and also from their reading of Montesquieu, and particularly his chapters in the Spirit of the Laws, which discuss the British Constitution. So what Madison wanted to do was to kind of improve the quality, was to involve judges in the actual business of legislating in an advisory capacity plus ab initio from the beginning, in the hope that you'd preempt or kind of reduce the number of problems you might encounter later on. And he presented this proposal at the convention, and it was discussed quite vigorously on a couple occasions. It had strong support from James Wilson, a Pennsylvanian of some prominence, who was also a member of the first Supreme Court under Chief Justice John Jay. Eventually, the measure was defeated, as we all know, but the comments on it are quite interesting, because what the comments demonstrate is that the critics of the proposal said this would actually ask judges to act in an improper capacity, and that the best occasion for judges to determine on the basis the independence that Article III would eventually give them, whether laws were constitutional or not, would come to them when cases and controversies properly presented the right set of facts for their review. Now, there's the strongest statements we have about whether or not the idea of federal judicial review of the constitutionality of both federal and state legislation was part of the original understanding, original intentions of 1787 and 1788, really come out of the debate over Madison's counsel. So Madison's counsel shows that he was willing to modify in kind of curious ways the idea of strict judicial independence as being wholly separate from the legislative process on the one hand, and then the response to it indicates that other framers of the Constitution felt that the whole purpose of judicial independence would be to lay a foundation for the doctrine we eventually came to call judicial review.
So interesting. Mary Sarah Bilder, so Jack Rakove has put on the table the centrality of this Council of Revision. When Madison thought about the Council of Revision and about judicial review, did he see judges as enforcing separation of powers limits or federalism limitations or the Bill of Rights or all of those? And did his views change? In your book, Madison's Hand, you say he didn't talk much about judicial review at the convention, but what kind of review did he see judges as exercising, and how did that change?
Yeah, I mean, I think Jack makes such a great point about how, you know, if we take the term judicial independence, we have to figure out what do we mean by judges? What's their role in the Constitution as a system of government? And then what does it mean to be independent? Who are you independent from? And I think what's so interesting about this period is that a set of ideas that had been established in the constitutional history of Great Britain about what judicial independence means has to be completely rethought. Because in Great Britain, a long tradition through the 1600s and 1700s involved the idea of independence of judges, but judges aren't separated, so they don't have a separated function, and they understand independence to be very much independence from the king. And there's a lot of the stories of the constitutional battles in the 1600s around the revolution, and then re-understood in the 1760s when George III comes to power, involve key moments where judges are not independent. And what they mean by that is that judges before the English Revolution, before the sort of the 1701 Act of Settlement, served at the will of the king, at the king's pleasure. And so there's a great battle over the 1600s and about the idea of judges beginning to serve bene gesserit, on good behavior, or as long as they behave. And that's one giant, enormous battle that they have. And then in the 18th century, that obviously for the American colonists is a huge battle. Their judges don't sit basically with good behavior tenure. And also their judges are controlled by salary by the crown. And so those two elements, which we don't think of, we tend to think of this question in terms of checks and balances, separation of power, judicial review, but that's not how they're thinking about it. The two key provisions for them are, do you have a good behavior tenure, and who's paying your salary, and can it be reduced? And those are the two complaints in the Declaration of Independence about the judges. Are the judges have been made to be at the will of the crown because they don't have good behavior tenures, and they serve and their salaries can be changed. And in that sense, if we think about the framing, Madison's he's just not that interested in the judiciary. He thinks the Council of Revision will pick up a big part of the job with respect to what we would think of review of congressional legislation. And he assumes that the negative Congress will review state legislation. And he actually complains to Jefferson at the end of the convention that one of the biggest problems with the Constitution is the loss of this congressional review of state legislation, which is what the Privy Council had done in the colonies. But what they do build into Article 3, which is very under imagined, is those two key provisions, that judges are going to serve on good behavior, which we come to construe as lifetime tenure, and their salaries can't be reduced in office. And the idea there is, therefore, judges are going to be independent, but in the world where what you're being independent of the crown, that's one understanding of independence. What does it mean to be independent when power lies in the people? And that, of course, is the whole problem, is when power lies in the people, when you understand the Constitution to be the will of the people, when you understand all the branches to be the will of the people, who are you independent of becomes a much more complicated problem. And I think that a lot of the early period is trying to work out, what does this tradition of judicial independence look like now that authority is in the people, as opposed to the crown, where it's sort of easy. You're either with the crown or you're against the crown.
That's so interesting, and framing it that way seems exactly right. And Hamilton says in Federalist 78, a conflict between the statute representing the will of the legislatures and the Constitution representing the will of the people. The judges prefer the principle to the agent, but who's the people? So Jack, you say that the central battles over judicial independence during the Marshall Court weren't focused on Marbury, but on McCulloch and on the interest, on the scope of congressional power. And if you interpret congressional power broadly, as Hamilton does, that has a totally different vision of the role of judges than if you interpret it narrowly, as Jefferson did. So tell us about the debates between Hamilton on the one hand and Jefferson and Madison on the other about judicial independence during the Marshall Court.
Ooh, that's a tall order.
That's why you're here. I'm really eager for you to help
let
us
me back up
understand it.
slightly. So Mary, if you haven't read the history as deeply, to be honest, as the two of us have on pretty much on a daily or weekly basis. So one of Madison's key proposals in 1787 would have been to give Congress, we would say a veto, but the preferred term, a negative on state laws. And that measure was, although the convention continued to discuss it almost down at the end, the measure was eventually killed in mid-July, right after the critical vote on giving each state an equal vote in the Senate. And in its place, we see the first appearance of the Supremacy Clause, which for all intents and purposes does create judicial review, imposing it explicitly on judges at the state level. And I think most scholars implicitly assuming that, well, it has to be applied directly to judges at the state level because you can't be 100% sure of their confidence or the sense of their obligations. Implicitly, of course, federal judges are going to have the same power. The question arises, so if you assume that a concept of judicial review was either implicitly or explicitly involved in the Supremacy Clause and in other discussions, against whom is it most likely to be directed? So everyone who's going to listen, and for all the distinguished brethren in the audience here, I'm sure most of you were taught this at the time. The idea that Marbury versus Madison is the decisive case in terms of quote unquote establishing. This is Alexander Bickle's language in his famous book, The Least Dangerous Branch, in terms of establishing the doctrine of judicial review, has become kind of, I don't know, a shibboleth or a kind of, a high statement of judicial theory. What I've always argued as a historian, because I am actually a Madisonian, not just in terms of my interest, but really in terms of my philosophy, is that Madison's analysis says that the most serious problems of maintaining the federal constitution are going to arise not in controversies between Congress and the federal courts. It's going to involve really the problem of what's going to go on at the state level, where what happens if you have, Madison anticipates a kind of McCulloch versus Maryland kind of situation in which states are going to act somehow in defiance of some major act of some major act of federal legislation. So the way I teach it by Stanford undergraduates, and but I hope you won't mind if I take this liberty with you as well, is to say if you had a choice when asking which of these two cases is a better indicator of the main purpose of judicial review, and I think this echoes Justice Holmes as well. That whether or not the Supreme Court or federal courts in general had the power to overrule Congress, that's a secondary consideration. They don't have the power to overrule the state courts, then we're in big trouble. And so I think if you have a choice between Marbury, which is 1803, and McCulloch, which is 1819, 1819 is the more important case, and it's more consistent with Madison's theory, which I think remains today. I think remains an extremely powerful, indeed accurate theory. That the real problem is what do you do about misbehavior, however you want to define that, at the state level. I'll just add one footnote here. When by the time we get to 1819, which of course is 30 years after the Constitution's been ratified, Madison is much more sympathetic to judicial power and to its importance 30 years later than he had been, as Mary was suggesting, at the time the Constitution was written. What he remains nervous about, and Jeff, this will tie into your question, is he doesn't mind the holding in McCulloch in the abstract, but he doesn't like Marshall's reliance on the broad Hamiltonian reading of the necessary and proper clause. Because by Madison's way of analysis, both going back to the late 1780s, early 1791, the famous debate over the bank, if Madison's main concern was to how do you get the legislature to try to limit itself, to teach the legislature that the necessary and proper clause is wide open, is essentially an invitation to legislate with as much discretion as you want to exercise. That would run against Madison's underlying concern that the legislative power remain the most dangerous element, or what he called the impetuous vortex in Federalist 48. The impetuous vortex of the legislature remained the most serious source of constitutional imbalance. So I think he was amenable to the holding in McCulloch in general, but he didn't like Marshall's reasoning because Marshall was a full-blown Hamiltonian. In in 1819, as he'd been pretty much in 1789. And he didn't want that kind of broad Hamiltonian reading of necessary and proper to prevail.
Fascinating. Can I ask you, Mary, to say more about the difference between Hamilton, Madison, and Jefferson? Jefferson and Madison, unlike Hamilton, want a Bill of Rights, and Jefferson says the courts will enforce it. And yet in the Marshall era, Jefferson ends up siding with Spencer Roane about the most radical questioning of judicial power to revisit state court decisions. My broad question is, were Madison and Hamilton and Jefferson being opportunistic and basically shifting their views about judicial review based on whether they like the results, or did they have a different vision of what kinds of rights judges should enforce?
Yeah, I mean, I think, and I'm going to throw John Adams in, because I think Adams, when you talk about the judiciary, is such an important person. He's not at the convention, but his book, Defense of the Constitutions, was serialized in a paper that summer, and he's very influential in the way that the 3 articles get written. And so I think if you think about what happens in the period between, let's say 1787, 1789, and up through, if you take to 1820, so that's it's almost a 50-year period. And one of the things that happens is the judiciary begins to figure out what should its role be. Because again, coming back to Article 3, which is the smallest article, and Article 1, Congress has lots of specifics in it. Article 2 about the executive has quite a few specifics. Article 3 doesn't have a lot of specifics. It just says there's one Supreme Court. And so a lot of what happens in this period is everybody's trying to sort out what should the judiciary do, particularly what should the judiciary do, the federal judiciary do, with respect to the rest of the constitutional system. And if you think about Federalist 78, Hamilton's view on that, one of the things that I think is really interesting is if you read Federalist 78 very carefully, Hamilton says, the judiciary is not going to be that dangerous for the political rights in the Constitution. And I think what he means by that is some sense of the political aspects that were written into the Constitution, things like habeas corpus, no titles of nobility, these kind of classic British constitutional rights. And then he goes on to say, there's other things then, he uses the word independent, that an independent judiciary can do. And this is where I think he does tie a little bit to the concerns that Madison has, because he says the people or legislation can go through too fast. It can kind of be a product of a moment, or they're often worried about sort of partisan, conniving demagogues pushing legislation through. And one of the things that the judiciary can do is almost like slow that down. And so that's one of the things he says in Federal 78 is the judiciary can sort of help balance the impulsiveness of legislation. And then he goes on to say another problem with legislation, and again, I think he's thinking at the federal level, but also at the state level, is that legislation can be overly severe with respect to private individuals. And one of the things the judiciary can do is help mitigate that severity. And he says if the judiciary sort of slows things down, mitigates the severity, pulls things in, that will actually in turn encourage legislation to be more careful and more specific. And so in some ways, he's seeing it as a sort of back and forth in what Adams would have assumed was the more important thing, a sort of checks and balance kind of way. And so I think that one of the interesting things, if we think about that aspect of this topic of judicial independence, what sort of the role of judges is the Supreme Court justices in this period are trying to figure out what does it look like for their role. And under the First Judiciary Act, there are no circuit court judges. There's only district court judges and the Supreme Court judges. There's 6 of them. My students are always like, how did that work? I'm a big fan of an even number of justices on the Supreme Court, but because you don't have a majority rule situation, but they're trying to figure out what does it mean to be a judge. And one of the things they begin to do over this period is try and and focus on how does judging look different than ordinary politics. And so a lot of what they do in this period that begins to establish this idea of judicial independence is they turn work down. So, you know, can you give advisory opinions? No, you can't give advisory opinions. How about you solve all the problems of who gets pensions? No, we're not going to do that. You know, like literally the beginning of the court is like, yeah, no, we're not doing that. We're not doing that. We're not doing that. And that also we're not going to do. And Washington keeps being like, how about you guys do this? No, we're not going to do that. But what they do in that space, and Marshall's a very important aspect of this, is they begin to develop this idea that judging is its own important task. And it's its own important task in thinking about what it means to be judges for the people, interpreting a people's constitution. But even in this period, judging, the federal judiciary looks very different than we do today. Because I think today, if we think about what being an independent judiciary looks like, we often think of the Supreme Court and we think of the Supreme Court's big building, but they don't have that building until the 20th century, right? I mean, that building is a product of when you get a president who decides to be a Supreme Court justice and then decides, wait, well, how come we don't have a building? The judiciary is embedded in some ways inside Congress. So all through the 19th century, the judiciary is sitting, the federal judiciary, the Supreme Court is sitting inside of Congress. And so there's a way in which our understanding of this very clear separation is, I think, much more a product of the 20th century than it is in this early period. And that's why I think sort of they assume there will be judicial review powers. Everybody gets that there's judicial review powers. The Privy Council had always bounded what the colonial legislatures and colonial courts could do. But what that means in a world where every branch is claiming to be interpreting on the side of the people feels different. And so what happens for the federal judiciary that's just incredibly difficult is trying to figure out, how do you not become the king in the room, right? How do you not insist that we're just doing this and we're really the ultimate will, but how do you work in a checks way to interpret the will of the people? How do you make judicial review be meaningful in terms of protecting the rights of the people in the Constitution, enforcing the limits in the Constitution, without becoming a new kind of king, without insisting that you're the ultimate and only decision makers? And I think that's the great problem for the judiciary throughout this whole period.
Jeff, I just want to add one point to this, and this may seem a little anomalous to the audience, but I think one way to buttress or deepen Mary's point is to say that the question of who are the real decision makers within the judiciary branch coming out of the Revolutionary period, are they judges or is it actually the jury? I mean, if you go back to John Adams in the 1760s, I quote him at some point in my work, says, jury should be perfectly competent to decide matters of law and fact alike. And so I think when you start having the Supreme Court justices riding circuit, from the start, often they give addresses to the grand juries, who are supposed to be, pursuing whatever charges are going to be brought under federal law. That's an effort to kind of bring the jurors up to the emerging judiciary's own level of expertise and knowledge, but it also says they see they have a kind of obligation or also an opportunity to kind of start playing a much more creative, directive role in terms of law. So how the judiciary defined itself institutionally in a period where the tradition of thinking juries were competent to decide both matters of law and fact alike is another one of those kind of mysterious historical changes, which may seem somewhat obscure and kind of antiquarian today, but which 18th century scholars like Mary and I you have to worry about actively.
You've both identified a shared concern among Adams and Hamilton on the one hand and Jefferson and Madison on the other, with faction and with separation of powers and maintaining those boundaries. And I want to ask, was there a partisan valence to conceptions of the judiciary at the founding? On the one hand, the Federalists under Hamilton favor broad congressional power and loose construction and fear the mob, and the Jeffersonians want strict construction and constrained power and fear aristocracy. did that affect their vision of what judges should do or not?
Well, I mean, I think one of the things, when you talk about independence of the judges and you think about what that meant in the British constitutional system, it was understood to be a political question. And what they meant by that was it was understood to be what independent judges did was they stood up to the king. And so I'm working on a biography of the great constitutional historian, Catherine Macaulay, and she tells a story that was widely reproduced and was very influential on John Adams. And he writes a long set of newspaper editorials about judicial independence. And there's a very famous case involving ship money. The king's sort of like, I'm going to tax everybody. And it goes to the court. Can the king tax everybody instead of Parliament? That's the short version. And 7 judges say yes, and 5 judges say no. And there's a very key judge, George Crook. And George Crook, according to the histories and Macaulay and what Adams and the founders read, said, I'm scared of the king and I don't want the king mad at me and I don't want my salary cut. And so I'm going to vote in favor of the king's side. And George Crook's wife goes to him and says, I don't care about poverty. I don't care about misery. You should do the honorable thing. And so he votes against the king. And then at the time of the English Revolution, all the judges who voted for the king were impeached. And this becomes a key story about what it means to be, what judicial independence looks like. And what that story comes down as is a story about what does it mean to stand up to sort of political partisan power that is against the people. And that's the narrative that really comes down. And so when you think about, is it the Jeffersonians or the Adams, right? The tension there is once you develop a political system that the framers didn't anticipate, which has established political parties, and you amend the Constitution with the 12th Amendment to institutionalize those political parties into the election system. That's what the 12th Amendment does, is it basically makes sure that having a political party is the way to gain power. Then this question of how does the judiciary fit into the very, in some ways, globally unusual two-party American political system becomes very complicated. Before the 12th Amendment, it's not that there aren't, there aren't parties going back and forth, but it doesn't necessarily look like they're going to be institutionalized forever. And then I think that's a really hard question for the judiciary and for what it means to be nonpartisan is once you have a very strong two-party system, where does the judiciary fit in that?
So, I think I would add to Mary's point and maybe shift it a bit by saying, to my way of thinking, the critical moment historically comes between the passage of the Alien Sedition Acts in 1798 and then Marbury versus Madison, not for its own sake, but just as an outcome of that struggle in 1803. And the reason I say that is, so it's a wonderful, for those serious in the history, there's a wonderful book by a guy named Wendell Bird called Criminal Descent, which is part of a series of books he's doing on the active prosecution of the Sedition Act cases at the very end of the 1790s during the so-called quasi-war with France, where the amount of collaboration, one could say collusion, between Secretary of State Timothy Pickering, who was the main player here in the administration, and some of the federal judges, led I think by Samuel Chase, who's also from Maryland as a Supreme Court justice. In terms of arbitrarily prosecuting their Republican, meaning Jeffersonian, Madisonian opponents on the one hand, and protecting Federalists on the other, even when they say things critical of John Adams as president, becomes quite significant. So there is a deeply partisan moment at the very end of the 1790s where the question of actually thinking politically of the relationship between judiciary and the executive is becoming problematic, or at least becoming, particularly as the Republicans see it, Jefferson, Madison, and their supporters see it, is becoming quite problematic. That's all the background to Marbury versus Madison, because then you get the Judiciary Act of 1801, which most historians still see, I think correctly, as a kind of final effort by the Federalists to lock them, to retain influence or potentially control over the one institution that they can still dominate, through the appointment of the so-called midnight judges and the kind of last minute Judiciary Act of 1801. The party's about to go out of power, but they want to lock themselves into, at least give themselves some deeply entrenched stake in national government, through the judiciary. I mean, that's all the political background to Marbury. So Marbury becomes an interesting case, not I think because of its great doctrinal significance, not because of the way it's still taught in many law schools, but as a consequence and an illustration of how deeply entrenched. And of course, the partisan relationship was. It's also worth going back and saying in 1789, when Washington starts, making nominations for both the Supreme Court and the federal district courts, the question of loyalty to the new regime became a major factor. That's to say, you would expect the preponderance of judges appointed, nominated, and confirmed in 1789, 1790 to be Federalist partisans in the sense of enthusiastic supporters of ratification of the Constitution. The problem that arises then is once political parties start forming in the middle, seriously in the mid 1790s, then the depth of partisan passion is ratcheted up, and the question of what does independence mean when the partisan forces are running so strong. Now I shouldn't go too far with this, but it's not, in some ways, it's not like the situation we're confronting today. So.
Fascinating. Well, we've worked our way up to Marbury, and Mary, do you agree with Jack that this is the time when all the partisan forces you've mentioned are coming to a head? The Alien and Sedition Acts prompt the impeachment of Justice Chase and the effort to change the size of the court. And how would you see Marbury? What was the assertion of judicial review controversial or not? And to what degree did it presage our current battles?
Yeah, no, I think the sort of current scholarship here is pretty clear that everybody assumes there's judicial review. Nobody's interested in that part of the opinion. And in some ways, that's not even really what Marshall's talking about. The part of the opinion that at the time is very dramatic and controversial is the notion that there are aspects of the executive branch power that are not completely political and partisan, that there's parts of the government that have to run regardless of which political party, so to speak, are in power. And there's sort of some things that you get to do because it's your party, but then there's a whole lot of other stuff that is sort of part of the fabric of the way the Constitution runs. And Marshall's very clear that you have to insist on this. And then the part that's the judicial review piece, that sort of part of the opinion, if you go back and read that, one of the things that Marshall says over and over again is we have a written constitution. And what he means by that is we have a form of government that is written down on paper. And there's something about that changes the way that we have traditionally understood government to work. And that puts the judiciary in a new role. And he sort of almost, in some ways, he doesn't know he's going to be on the court at that point as long as he is, but there's ways in which what you can really understand the very long period of Marshall's tenure to be about is sort of working out what does it mean to be a branch of the government interpreting a written form of government and be respectful of the fact that there are other branches, but also understand yourself in some way to be representing the people ultimately. And I think Marshall very much understands that position. One of the things that's a sort of curious note in terms of the pieces, Marshall gets the position, but one of the people that Washington had wanted to give the Chief Justiceship to was Patrick Henry. And Patrick Henry turns it down. He's older, he doesn't want to do it. But there's a way in which
he's lazy.
I'm going to give him credit for being sort of done there, been there, done that, gonna be quiet and retire. But that tells us something about how certainly during Washington's time, the question was, were you favoring a sort of broad constitutional forward-leaning understanding of the government. And he actually sees Henry, who had been, the great anti-federalist, as at that point willing to do that. And then by the time you get to the Marshall years and you get the development of two political parties, then it becomes harder to imagine putting the other political party on the bench. But so I think Marbury is just incredibly important as the sort of turning point moment, but not because it announces something completely new.
So interesting. Time for closing thoughts in this wonderful discussion. I hear both of you saying, Jack, sum up if you can, what was agreed and what wasn't agreed about judicial independence at the founding. I hear you say that there were
30 seconds.
Well, you can do it. I know. That's why you come all the way from California.
Well, I just flew in from the coast and I'm flying back this afternoon.
Yeah.
It's a tough one, Jeff. I mean, I think I would echo the point that Mary just made, that I was just reading Keith Whittington's, one of his books on, who's a very distinguished scholar at Princeton on this. I think the novelty of the acceptance that the Constitution was law, not just in the new American sense of the term, that's to say supreme fundamental law which regulates everything government could do thereafter under its directions, but it was also law in a more conventional sense. The document was there, it had to be interpreted, you had to know, you had to develop rules for its interpretation. That became the foundation for the development of a distinctively American conception of the judicial function. I happen to think, and this will be my last provocation, that it's helpful for us to think, and Mary might disagree with this, I'm not sure, based on what you said about Macaulay, but it seems to me the idea of constitutional law per se is an American invention. The term would not have meant anything, certainly perhaps before 1776, but almost early before 1787, 1789. There are constitutional norms that judges could, in the British tradition, that judges could occasionally invoke. But the idea of having the Constitution as a text against which other texts would be read and interpreted, that it seems to me is a major American innovation and departure. And if you go back and read Federal 78, it's the first mature statement of a theory of the judicial function. The real purpose of Federal 78 is not to justify judicial review, it's really to justify the idea of an independent judiciary, and judicial review becomes the byproduct or the consequence of that argument. I mean, the larger part of the essay is really a discussion of judicial independence per se. Judicial review is an illustration of what that what that concept of independence is may come to mean.
Fascinating. Last words to you. What was agreed and what was not agreed about judicial independence?
Yeah, I mean, I think what was agreed at the federal level was what's in the Constitution, pretty minimal requirements, but on good behavior, lifetime tenure, friends, and your salaries can't be reduced in office. And then everything else was a little bit up for grabs. And I think in that sense, Jack's point about this sort of, one of the things the court will do, the federal courts will do over time, is develop a body around interpreting this new written instrument, the Constitution. And that's very new. It will come to be known as constitutional law, but that type of a sort of separated law doesn't exist in the British tradition. And that's a very important thing. And how one understands that changing over time becomes a very important thing. And Hamilton, in some ways, in Federal 78, prefigures this, because the very last thing he says about why should you have an independent judiciary is he says basically that's going to be really hard. And it's going to involve reading lots of stuff and precedents. And he said the precedents over time and the sort of history of the own interpretation of this will become more and more complicated. And it will require people to sort of be willing to devote a lot of study and time to this. And that's in part why we give judges sort of lifetime tenure, is to be super thoughtful and careful about what it means to be interpreting a constitution on behalf of the people.
For illuminating our understanding of judicial independence at the founding, please join me in thanking Jack Rakove and Mary Sarah Bilder. Wonderful. So great. That's excellent. Thank you. Great. And we're going to move right into our next panel. And let me go get our panelists. Friends, it is a pleasure to introduce our next panel to discuss judicial independence in the 20th century, and I will introduce them in alphabetical order. Neal Devins is Sandra Day O'Connor Professor of Law and Professor of Government at William and Mary Law School. He's the author of Shaping Constitutional Values, Elected Government, the Supreme Court, and the Abortion Debate, and other important books, including The Democratic Constitution, and most recently, The Company They Keep, How Partisan Divisions Came to the Supreme Court. Allison or Larsen is the Eng Research Professor, Associate Dean for Research and Faculty Development, and Alfred W. and Mary I. W. Lee Professor of Law at William and Mary, where she directs the wonderful Institute for the Bill of Rights Law. And Marin Levy is Professor of Law at Duke Law, where she serves as Director of Duke's Program in Public Law. She's co-author of Federal Standards of Review, Appellate Court Review of District Court Decisions and Agency Actions, and the forthcoming Written and Unwritten, the Rules, Practices, and Internal Operations of the United States Court of Appeals. Welcome, friends. We're going to jump to the 20th century. You've just heard this marvelous discussion of judicial independence at the founding. And I'd love to begin with some broad reflections from you about how we got to the 20th and 21st century. We began at a time when the party system was just up and running, and so little was agreed, as we just heard from our panelists about judicial review, to a world where judicial appointments are so entrenched in partisan politics and polarization pervades all the branches of government. Maybe why don't we begin with you, Marin Levy, and what are your reflections about how we got here?
Sure. Well, first, I just want to say thank you. It's such a privilege to get to be here with this group today. So it's a great question, right? How do we get to this point today, and how do we think about judicial independence the way that we do now in the kind of robust sense? I think there are a few different stories that are worth telling, and I'm going to focus just briefly on two of them. So the first thing I think to appreciate that we might overlook from the modern day is just how much the courts grew up over this time, right? I mean, truly, we saw the expansion of the courts from 1789 to today. So I'll just say a word about that. But then also this key part about how the courts came to govern themselves and really administer themselves. I think that's happening in the background of all these other big moments that we think about, like with the court packing plan. So I'll just say a quick word on those two. So something I always like to go back and think about is in 1789, we have fewer than 20 Article III judgeships. This is the federal judiciary, as we think of it, was such a small institution at the time, right? Fast forward to 1900, it's only a little more than 100 judges. Of course, by the time you hit the end of that century, we're up to 850 Article III judges, right? So this is a major expansion of the federal courts, right? Again, this really becomes a robust institution during this time. And with that, right, it has real administrative needs. And this is the other key part of the story that I think is worth emphasizing. So if we go back again to the beginning of the federal courts, the administrative piece of it was actually housed in the executive branch. So it was actually the Department of the Treasury that was tasked with dealing with the kind of financials of the courts. This then gets passed over to the Department of the Interior for a bit of time. And then by the time we get to 1870, this is when we get the Department of Justice. And again, this will feel surprising to modern ears. It's the Department of Justice that's the principal administrative agency for the federal courts, right, for decades and decades to come. So what this means is that it's actually DOJ that's tasked with preparing the budget for the federal courts, right? They're the ones that are keeping the statistics for the courts, like what is the workload and all that sort of thing. That's housed within the executive. And what this ends up doing by the time we hit the 20th century is it creates these sites of tension between the branches. So just a couple quick kind of fun points on that. So in 1934, right, we have the Great Depression, and we actually then have the Attorney General turning to the courts and saying, I'm ordering a 25% cut in your budget, right, which is a shocking thing to think about today, right? If the Attorney General of the United States told the judges in this room, I'm cutting your expenditures by 25%. Right? So again, we have this really interesting contest between the branches. And at the same time, we have Congress coming in and saying, we're actually going to cut the pay of senior judges by 15%. Right? This is all part of the kind of cost-saving measures. Now, that's something that the Supreme Court then ends up pushing back on and rejecting in a case called Booth in 1934. So this is all to say, though, that we see these tensions between the branches, and it becomes clear, I think, for the federal judiciary that for it to assert real independence from the other branches, it needs to be taking the administration, right, of the courts in-house. So we actually see a little glimmer of this in the 1937 court packing plan of all places. So I think this is an overlooked provision of FDR's plan, that they were going to create an office called a proctor who was going to be in charge of collecting statistics about the courts, right? Pulling that administrative piece from the executive over to the judicial branch. So of course, that doesn't work out. But within a couple of years, instead, what we get is a working group created by the Chief Justice of the United States, Charles Evans Hughes, who brings together several of what we would call today chief judges from around the country, working with representatives at DOJ and the ABA, and they come up with a proposal to create what then became the Administrative Office of the U.S. Courts, which came online in 1939. So I think a really big part of the story that we can talk about is how today we see the judges pushing back and saying, we get to mind our own shop, but there really is this important story about that shop kind of coming into formation during this time, and that allows the judiciary to kind of stand apart, right? It doesn't have to then go through the executive to really be kind of an equal branch in all of this.
Such important reminders about the internal administrative reforms essential to the story, and how memorable to think of the office of proctor, which was thankfully resisted, but just great. Neal, Devins, how did we get here?
Well, when we look at where we are today, the Reagan presidency is so critical in the story. Before Ronald Reagan was elected, presidents did not think about ideology when appointing judges and justices. Dwight Eisenhower, of course, appointed Brennan and Warren for political gain, to reward Warren for his help in California. Truman gave judgeships to personal friends, often conservatives. Before Reagan, there was no ideological divide between Democrats and Republicans. Democrats occupied every niche on the spectrum. There were Southern Democrats. Republicans occupied every niche on the ideological spectrum. There were Rockefeller Republicans. George Wallace, when he ran for president, said, I'm running for president because there's not a dime's worth of difference between the Republicans and the Democrats. Reagan is elected in 1980, and he runs in an effort to make ideology relevant. He makes ideology relevant in judicial selections, working with Attorney General Meese. There's a focus on identifying conservatives. At the time that Reagan is president, there isn't a well-established conservative legal network like there is today, and we can talk about that later, I hope. But at that time, there's an effort to find conservatives. There's an effort to get young people, in part through the Federalist Society, into the Justice Department to be credentialed to become judges later in time. But in understanding where we are today, the key moment is Reagan and the shift to ideology and judicial appointments and the shift to separating Democrats from Republicans along ideological lines.
Thanks so much. Maybe a thought on that provocative point. Do you agree that the ideology became relevant in the 20th century only in the 80s? And what about the progressive era when Wilson chose Brandeis and FDR, of course, chose his justices? And how would you say we got here?
There's a lot in there. I definitely agree with Neal that like the 80s marked a change in terms of the politics of judicial appointments. And I think that's part of the story of judicial independence, because at least in the eye of the public, you're only independent from politics if you act like it. And that goes into sort of what I was going to say about the importance of norms of judicial independence. So a lot of the story of how we got to where we are today, there's no change in Article 3. There was no change, not a dramatic change in the statutes that touched on the judiciary. It's about norms of what is out of bounds and what is not out of bounds in terms of political repercussions to judicial decisions. And that's important because I think it shows the fragility of judicial independence. Because if it's really about bipartisan norms of how we leave the judges alone, then if those norms erode, I mean, I don't have to paint the ugly story for you, but that is a real danger to judicial independence. And if you'll allow me a brief anecdote, which I borrowed from my friend Tara Grove, who's going to be here tomorrow. When Newt Gingrich ran for president in 2011, this is 2011, part of his platform included a proposal to abolish the Ninth Circuit because they were out of step with mainstream America. And that proposal was met with bipartisan criticism. What? You can't do that. Like that would be totally crazy and a real invasion of judicial independence. His answer was, if you read Article 3, Congress has a lot of power to, ordain and establish the lower courts. That includes, he said, getting rid of courts that are no longer necessary. The reason that we think that's out of bounds has everything to do with bipartisan norms and assumptions. So that means it's incumbent upon us, I think, in order to protect judicial independence, to bolster those norms. So that's, I think, an important part of the story.
Fascinating. Well, if we pull back from the 20th century to today, at the dawn of the 20th century, we had Gilded Age judges striking down progressive economic legislation, and Democratic presidents from Wilson to FDR pledged to change the court. So judges upheld that legislation, and that succeeded, of course, and came to a head in the New Deal. And for a while, judges upheld the legislation. And then, as Neal Devins said, President Reagan came and pledged to appoint strict constructionist judges who would reinstate limits on federal power that had been dormant since the New Deal. And that leads to the current situation. Marin Levy, what do you think about that as a just description of what happened? And tell us about the role of the administrative reforms that you mentioned as part of this story, because it was in the 20s that Chief Justice Taft built the Judicial Conference and created the administrative apparatus that made a strong and powerful judiciary possible. And I know you've been studying further administrative changes that have strengthened that independence.
Yes, absolutely. So here's I think a story that helps to bookend the century that has us focus a bit on the lower courts, but I think it's really useful here. So as we said, we get these different we have the Judicial Conference, we have the AO, and this becomes crucial at a time, as we mentioned, where the courts are really expanding and the caseload, of course, is really rising significantly in the federal courts. And so one place where I think we see a really interesting contest here and the assertion of the norm of judicial independence comes into play with unpublished decisions. Right? So as the caseload is rising, this is in the 50s, 60s, and 70s, one of the first moves we see from the federal courts is the Judicial Conference stepping in 1964 and saying for the first time to the judges, you don't actually need to publish formally every single decision that's going to come out of your court. Right? So this is really speaking to the courts of appeals. So if you have a decision that's really not meant to be precedential, just applying precedent that's well established, it doesn't need to be in the Federal Reporter. This is a huge shift for the courts. And then what comes out of that is the decision by each of the different circuits as to how to respond to that. Right? So when it's appropriate to publish a decision and when is it fine to forego that, and then how you treat the decisions that aren't published. right? So those aren't precedential and they're not meant to be cited as such, but can you even cite them at all to the courts? And there was a split on this, as many in the room will remember. So what this then ended up with was, by the time we get to the early 2000s, we have Congress stepping in and saying, we're hearing some concerns about these unpublished decisions, and in particular in some circuits that you can't even cite back to these opinions. So what does it mean to have these courts if you can't cite back to a prior opinion? What's fascinating about this moment in time is that when the hearings are going on, you have members of the judiciary coming back and saying, this is really our territory, and it's not appropriate for Congress to be stepping in and telling us what to do with our decisions. So you have then Judge Alito from the Third Circuit. You have the chief judge of the Ninth Circuit, Alex Kaczynski, right, testifying. And this is really what their point is. Again, this is the management of the courts that we're talking about. This is for us to decide, and we want to avoid a real confrontation between the branches. This is something that Kaczynski says directly back to Congress. And then what happens, of course, is Congress backs off a bit, and we have the judiciary itself coming up with a solution to this. We get a change in FRAP, the Federal Rules of Appellate Procedure 32, right? This is starting in 2007, that these are all decisions that can be cited to, but they're not meant to be persuasive authority. But so now if we pull back again, thinking about this in the larger lens, right, this is one of these moments where, because we have these different kind of sites now for administration within the judiciary, you can speak kind of in a unified way and actually push back against the other branches and say, this is our shop and we're minding it, and we don't want to have a contest. And then you see Congress really acquiescing and backing off to that. Right? So for all the politics that are happening in the background, for all the shifts that are happening with the Supreme Court, you actually get this really interesting kind of unified assertion in the lower courts about, right, this is our territory. And again, Congress really stepping back from that.
Fascinating. Neal, Devins, what was distinctive about President Reagan's effort to appoint strict instructions judges in the 80s? Of course, as you've noted, presidents have taken partisan valence into account throughout the 19th and 20th centuries. So there's always been politics in the nominations process, but what changed?
Well, I think Attorney General Meese made a concerted effort to develop a network of young lawyers who would be able to carry water, which is what we're seeing today. People such as Neal Gorsuch, Sam Alito, John Roberts, all worked in the administration. There was an effort essentially to be future focused. And one other thing that Meese did that was, I think, very smart politically was that he wanted people to be organized around ideas. So he used the Justice Department as a venue to have seminars on originalism where people like Justice Scalia would speak to, and people would essentially develop norms of decision-making that they would be committed to, so that when they later were eligible to become judges, they would be well-schooled in these norms, well-schooled in what the project was, and committed to the project. Their social networks were networks of conservative lawyers as well, and that reinforced the norms within the group. So Reagan was particularly good, or Attorney General Meese was particularly good in being future-oriented and laying the seeds for what we're seeing today with the rise of conservative legal network and the rise of the Federalist Society, and obviously the rise of textualism, originalism, and the like.
As we heard on the first panel, the debate between strict constructionists and living constitutionalists dates back to Jefferson and Hamilton and played itself out on the Marshall Court between Marshall and Taney. So to what degree did norms of there being a political valence to methodologies of judicial interpretation change in the 20th century?
Well, I think that's one important norm, is that judges will not decide cases based on the partisan affiliation of the president who appointed them. I think that's an important norm of judicial independence that is potentially vulnerable to change. I think another important norm is that presidents and political actors are going to comply with federal court orders, even if they don't like them. And that hasn't always been the case and is also, I think, vulnerable to change. And then the third one is the one I mentioned originally, which is that Congress isn't going to abolish courts because they don't like the way that the judges are making the decisions on that court. And if you sort of take them one at a time, maybe in reverse order from the way I had it before, I think the change to the first one, the one that led to the bipartisan criticism of the Gingrich suggestion to get rid of the Ninth Circuit, I think you can see that changing through, like even as late as the 1920s, you still had that conversation happening in Congress. So you didn't see that conversation, that norm changing until like the 60s and 70s. And that goes hand in hand with the second norm about political actors complying with federal court orders. So if you think back to Nixon and Watergate, so he says, he says to his political colleagues, I might not comply with a Supreme Court order that tells me to turn over the tapes. And the response was, oh, you have to do that, right? That's a norm of judicial independence. Contrast that to the massive resistance to Brown in the 60s, in the late 50s and 60s, which always startles my students. And I think it's a good reminder to, when you show that to a modern audience and they're like, what do you mean, like Supreme Court or no Supreme Court? We're not going to integrate these schools. I think following the civil rights movement, you have this creation of a bipartisan, a distance from that, that eventually leads you to what happened in US versus Nixon, and then, ultimately Bush versus Gore. I also think, the 9/11 cases after, the Boumediene, Hamdan, Hamdi, you have George W. Bush saying, look, I don't like these decisions from the Supreme Court, but I'm going to comply with them. That's a norm, a bipartisan norm of judicial independence. There's nothing in the Constitution that necessarily requires that. And then the last one is one that I think is really important for us in this room to reflect on. It's the importance of judges and the bipartisan norms of judges in, supporting and reinforcing the norm of judicial independence. So Neal and I have done work where we looked at en banc decisions, and we went back and collected them for time periods over 60 years. And the reason we were interested is because when a court of appeals sits en banc, all collectively, that's really an opportunity to see judges line up in partisan teams, all those appointed by Democrats versus all those appointed by Republicans. And so we were worried, and we were suspicious that we were going to see an uptick in what we call partisan reversals over time. But what we found, this is the heartening part of the story, we found like a good news, a bad news. But what we found was actually there was a strong resistance for 60 years to that use of the en banc decision. And I think that what we were touching on was a bipartisan norm of judicial independence. And then the sad news of the story is we also saw that it's maybe starting to change from 2018 to 2020, where there was a significant uptick in those partisan reversals. So that reason for that story is more of a, I guess, an important reflection point about how these, if they're just norms that protect judicial independence, how fragile they are and how maybe precious they are, need to be reinforced.
Very helpful to put those three norms of judicial independence on the table. One is immunity from Congress changing the size of the courts for partisan reasons. The second is obeying with orders that you disagree with if you're the president. And the third is bipartisan norms of judges themselves. Marin Levy, what light can history shed on those questions? And did the professionalization of the judiciary in the 20th century increase the strength of each of those norms or not?
Yeah, so it's a great question. I think, so just reflecting back a bit on what Ali was talking about with the fragility of these norms, I think it's worth noting, I guess, a couple points. One, and this is just now to reflect back something a lot of people have been thinking about for the last several years. So if you were to have conversations with legal academics and judges a few years ago, and we're thinking about the strength of different norms, the one that was always upheld the most as I think the most robust was right. We're not going to see any attempts again to pack the courts, right? We're going to be respectful of the courts as they are, and certainly we wouldn't do that in response to any kind of decision that the courts were reaching. So whatever else might be happening, whatever other norms might be broken across the executive, we're not going to see that sort of attempt from the political branches vis-a-vis the courts. And it's been quite astonishing in recent years to see that be walked back a little bit. And I think it's hard so even at this moment to fully say what's gone on with that norm, I think one thing we can all kind of think about is obviously the Biden Commission was created to study the Supreme Court in part to think about court expansion, court packing, and ultimately, kind of walked away from that. And I think a lot of folks think about the creation of that commission as a way of, in fact, not having to come out strongly in favor of court expansion or something like that. But I do think one thing that we're seeing, maybe going back to the idea of unifying the judiciary on this, is some resistance to all of that, right? Trying to actually kind of resubstantiate some of those norms. But I think, just to echo what Ali said, we're in a time where it feels a lot more fragile than I think any of us would have expected even a few years ago.
Neal Devin, compared now with the 30s in court packing, it's the obvious comparison. Threats of court packing that failed, claims that judges were deciding on partisan grounds or valences, and I suppose not threats to ignore judicial decisions, but talk of that sort of thing in the air. Is now different, or have we been here before?
Well, I think to build on what Marin just said, I think we're at a very precarious time now. The partisan division wasn't one earlier. We didn't have Republicans and Democrats lined up ideologically as we do today. So as a result, the stakes seem higher because there's a greater predictive value that if you nominate a Democrat, that judge will behave differently than if you nominate a Republican. And the world we live in is one where the affluent and well-educated tend to be the most partisan as well. That's the community that selects the judges, the community from which the judges come from. And I think it's a challenge for a judge today to rise above these partisan labels just because their priors are oriented in some fashion around their party, or else they probably wouldn't be nominated to be a judge in the first place, which also means the willingness of the other side to take action against them is greater. And I think the risks of court packing as a result are much greater today than they have ever been. And I think if there's a Democratic supermajority in Congress and the Supreme Court continues to decide cases the way it has in the past term, I think there's a real risk for court packing to actually happen.
Allison, what about the founding as a precedent for today? So arguably after the election of 1800, all three of your norms were being violated. The outgoing Federalists actually changed the size of the court to deny Jefferson the opportunity to make appointments. Jefferson absolutely is threatening not to obey Marbury if he's ordered to. And there's clear partisan valence. So weren't things even worse then?
Yeah, so I actually think that's a really important point because it shows when you think like, where does judicial independence come from? It comes from an evolution, like the way we think of judicial independence today, it comes from an evolution of norms since that time. So it's not baked into the Constitution fully. It's something that grew over time and can change, is vulnerable to change. I mean, I'll add on the court packing point, part of this is colored by hindsight. But when we talk about the 1930s court packing plan, we also discuss the resistance in the public mind to it, that it was actually ultimately proved to be not what the people wanted. We don't want to pack our courts. We want an independent judiciary. A difference between that and today, I think, is that you have people, you don't have people talking to each other necessarily. So one camp thinks court packing is essential and another camp thinks court packing is outside the bounds. So outside the boundaries. So this, what I've been talking about, these norms of judicial independence, sort of implicit in my comment is that they're bipartisan norms of judicial independence. And if you don't have the parties talking to each other, then you can't have the development and reinforcement of bipartisan norms. And so that makes me nervous. And it makes me agree with Neal that we're closer to the edge, to the cliff, than I think we were in the 1930s.
Marin, Levy, are things better on the lower federal courts, the inferior courts, the appellate courts, and to what degree do we see less polarization there at the Supreme Court?
Sure. Well, Right, it's funny to answer that question looking out into this particular
Of course,
audience.
that's why I asked. Very careful how you
And we
respond.
would certainly never say inferior or.
Just quoting the Constitution.
So it's a terrific question. I mean, I think the answer is, right, is there less polarization there? I think the answer is yes, and for a number of reasons. I mean, I think the judges in this audience can answer this far better than I can. If we look at the Court of Appeals, in the vast majority of cases are decided unanimously, right? 3-0. I'm seeing some nodding, that's encouraging. So, you know, part of that, of course, is just what the issues are, that a lot of the issues that come before the courts, I mean, these judges don't have discretion over their dockets the way that the Supreme Court justices do. So as a result, you have a lot of run-of-the-mill cases and they're pretty clearly decided. And so you get a lot of 3-0 decisions. And that, I think, is really critical for those courts, right? That you have judges lining up, and it's not about were you appointed by an R or a D. It's this is what the law is, and we're all in agreement on that front. So I think that's part of the story. Just what is the caseload, right? And so are you bringing together different groups of judges, again, regardless of who appointed them? I think the other part of the story is, and this goes back to what Neal was talking about, you know, there's been a huge focus, obviously, on the Supreme Court for quite some time. I think it's only more recently that there has been a focus on the lower federal courts and thinking about what those appointments look like, and also sort of, will those folks then be kind of sort of in a position that they could be elevated to the Supreme Court. And as a result, I mean, one way to think about this is when we look back to the Supreme Court, kind of the court that I think of us as growing up in, like there were swing justices. There was a clear middle on that court. And I think we still have some of that across the courts of appeals in a way that's so important, right? I mean, that there's more of a middle. I worry that we're losing that, the way that appointments have been going over the last few administrations. And this then, of course, dovetails with work, I think, that Neal and Allie have done. So this is all to say, I think, right, things look a lot better if we're looking at the courts of appeals and the district courts, but I do worry with the current climate and the kind of pressure on appointments that if this continues down this road, that we may see a little bit of a kind of coming apart, and that we're going to lose that middle that I actually think is really crucial for the federal judiciary.
Neal, Devins, you talked about the New Deal as a time of great polarization. Of course, in the progressive era, we also saw arguments for overturning judicial decisions by popular vote and arguments for court packing. And in the Civil War, when Congress changed the size of the court for partisan reasons, and there were certainly threats of failure to comply. So what about the thesis that there have been a couple of moments of constitutional change in our history, the founding, the Civil War, the New Deal, and then our current originalist era, beginning in the Reagan era. And this is what happens during the periods of transition.
Well, I think that's a very benign way of expressing it, because it does seem to be, as Marin was just talking about, that there are teams, in a sense, emerging today, and the shift is not one that will endure if the other team gets a majority on the court. There is not the middle that there once was, where you can build a consensus, you know, through the middle. If you just have opposite views and you consider the other view not to be legitimate and appropriate, you just hope that your side gets power, and then you will change the doctrine when your side gets power. And I think that may be the world we're living in or fast approaching. And I think with respect even to the courts of appeals, the efforts of state attorneys general to target certain lower courts, certain district courts, certain courts of appeals, if they're Republican attorney generals challenging Democrats, and if they're Democratic attorney generals challenging Republican administrations, you know, you're building this sort of team mentality, even in terms of how the lower courts of appeals are being viewed. And it's just a question of who has the numbers. And that's the way the Senate is approaching it. That's the way the White House is approaching it. You know, we obviously have the history of Merrick Garland and what happened just in recent months with Dianne Feinstein being out of the Judiciary Committee. I like writing with Allie because she makes things brighter than I would write on my own. But on my own, I am somewhat pessimistic.
Well, if I can just add to that. So one way to crystallize exactly what Neal's talking about. So if you think of, remember a couple of years ago when then President Trump talked about Obama judge, and the Chief Justice came out in a pretty remarkable statement for the Chief Justice to say there are no Obama judges, there are no Trump judges, there's only judges, and that independent judiciary is what we should all be very grateful for. That, I think, is a very strong norm of judicial independence that is in danger today. So if you want to think about, like, what if we do become like, well, there are Obama judges and Trump judges, and I don't have to negotiate with you because you're on the other team. I mean, that's a real shift from where we were even 5-10 years ago.
Right. And it requires the judges in some measure to take ownership of the judiciary and say that, you know, we may need to decide cases that don't match perfectly with what we think the right answer is, but to do so in order to make the courts stronger and to resist certain criticisms that might be otherwise directed at the courts.
So that we don't look like partisan warriors.
Right.
Well, I think it's time to sum up in this provocative and important discussion. And maybe I'll ask each of you just to share your thoughts with our really distinguished judicial audience about what lights history can teach them about how to maintain these norms of judicial independence in a polarized age. Marin, Levy.
Yeah.
Marin.
Sure.
Let's start with Marin, just to
Marin.
go in
Sorry.
order. Yeah.
I'm happy to let them have the hot seat first, and
You want-
I'll follow in a minute.
Or maybe I'll just invite you to sort of offer concluding remarks as you think best.
Goodness. This does feel like a hot seat all of a sudden, right now. I know
No,
what it's
no,
like to be
it's
cold
supposed to be a
called as a student. Yeah, I mean, I think we're all in this room because we recognize this is a very timely topic, right, on a number of fronts. And I would imagine that many of us here come from the position of thinking that it's crucial that the judiciary remain independent from the other branches and that we shore up these norms where we can. I mean, part of what I think is so difficult here, just being perfectly candid, is the way in which the judiciary doesn't have full control over these types of things, right? I mean, I think about it in the following way. I imagine telling my colleagues at the law school, you know, suppose somebody just said, here are the people who are going to be joining your faculty, whether you like it or not, right? And they are now going to be your colleagues for the rest of your life. Or I've always been struck by the way judges talk about their courts as like a family, as one put it, it's like where it's made up of all the in-laws, right? Like, and right, you don't have any control over who's joining your court, and these are the folks you now have to work with. And you know, we can talk about it as we've mentioned, right? The way the confirmation process has changed and really, I think, become quite problematic. So I guess where I'm coming out of this from is I really feel for the judiciary right now. I feel like judges are in a tough spot. And I do worry about the public's perception of the courts at this moment and seeing judges as partisan in a way that I don't think that they are, particularly if we're talking about the lower courts. So this is all by way of saying, I think, you know, we've seen these inflection points over history and we've come out of it. And I hope that when we look back in 10 years, we'll be able to say we came out of it again, and it was thanks to the actions of the judges, including folks in this room. But I do recognize this is a precarious point, and you know, this is not something that unfortunately everyone here has full control over.
Great thoughts. Thank you for those, Neal.
You know, I'm just going to echo that. I think that the judges are very much committed to making law-based decision-making, but there are different perspectives on what the right answer is that tend to be divided now along partisan lines, which is obviously creating a complication for judges who are doing essentially the same thing that judges have always done, but now it's easy to put a partisan label on it. So I just want to echo what I said before, that the judges may need to work together to overcome that, because the political actors are not going to help them overcome that. And let me close out by referencing another article that Ali and I wrote on the personalities of the different federal courts of appeals. And we found that by the courts investing in their own local cultures and local customs, we're able to strengthen communal bounds and collegiality between the judges. And that type of communal behavior and investing in the circuits and recognizing that the duty is primarily to the job of being a federal court judge and not to reaching necessarily one or another outcome. might be the most salutary thing, that the judges can do. And I hope that's something that resonates with some or all of you in the audience.
And I'll take the baton, right, as you said,
Yes.
and bring a little sunshine. So in researching that article, we learned some stories from the lower federal courts, and particularly the DC Circuit, and what Judge Edwards did to bring his court back from real partisan divisive culture. And it was things like lunches out, making sure that the panels are truly randomly shuffled and that you sit equally with somebody. You're not in the same company over and over again. Having more rules that make sure your work gets done on time, so that there's not pent up frustration about someone keeping your decision from going out, and making sure that you see members of the other team as human beings who are all part of a different team, which is the judiciary, and that team allegiance is more important than perhaps the allegiance that got you the job to begin with. So there are examples of success stories of these norms being reinforced, and these norms being, I guess, given to the next generation. We're not powerless, but it is a formidable job.
For giving us a ray of optimism, please join me in thanking our panelists. Wonderful. We'll reconvene in 15 minutes.
was the clock. I'm gonna wait. I'm just gonna wait.
Hi, everyone. Yeah. Welcome back. Welcome back. Yes, that's it. Thank you. Okay. Welcome back, everyone. Thank you for joining us for our program on the evolution of judicial independence. I'm Clara Altman. I'm the Deputy Director at the Federal Judicial Center. The Federal Judicial Center is the research and education agency for the federal courts, and we are really pleased to partner with the National Constitution Center on this program. We're really thankful to Jeff Rosen, to the staff at the NCC, and to all of you in the audience for joining us this morning. We just finished 2 panels this morning with historians and legal scholars talking about the history of judicial independence and its evolution, bringing us up to today. So it's fitting, we think, to round out that discussion with our 2 panelists in this last panel, 2 federal judges, to talk about their perspectives on judicial independence. So joining me all the way on the right of the, to my right, Judge Guy Cole from the 6th Circuit Court of Appeals, and to my immediate right, Judge Sarah Ellis from the Northern District of Illinois. And I think where I want to start our panel is with some definitions, to start with how you understand judicial independence and what it means to you. And I'll start with you, Judge Ellis.
Well, I think judicial independence is what it means to me is that we are able to make the decisions that we believe are correct in line with the law. And that we don't worry about our jobs, we don't worry about our safety or our security. We don't worry about what Congress or the president thinks, but that we get to the right decision and that we are accountable to the people. And we are responsible to the people. And we are protected and supported by the people.
Judge Cole?
Well, I'd like to thank the Center for having us. My definition is pretty much the same. I see judicial independence as the freedom for courts, trial and appellate courts, Supreme Court as well, to be able to decide a matter based upon the merits without any concern for legislative or executive interference or involvement or from any external source. So in my mind, we have a system in this country where we really don't have to worry about contact from outside sources. We don't worry really as much about threats from changes in government, changes that might, impact the overall administration of our courts. You look at some countries where when there's a change in government, the military comes in and political officials and judges are marched out of their offices. We don't have to worry about that. I mean, we have norms and conventions in this country where that's really not a concern. And, we certainly are challenged at this point in our history to try to protect those norms and those conventions. But at this point, we really are able to make decisions as judges based upon the merits of cases, based upon the record that is made by bankruptcy judges, magistrate judges, district judges, and in their cases at the Court of Appeals. The record comes to us, and based upon that record that is before us, then we can make a decision about how the case should be resolved.
So we've been talking this morning about a lot of the norms in the courts. We've been talking about some of the history of the politics and constitutional law. A lot of matters that those of us who are either steeped in thinking about this stuff or who are judges think about all the time. But I wonder about people who are not judges, people who are not steeped in thinking about this all the time in the way I think many in this room are. How would you explain judicial independence to them and what they might expect, or how might you hope they understand it? And that may be some of what you've already said, it may be something else. Judge Ellis?
Well, I think that the importance of civics goes a long way to making the public understand what we do and how important it is that we are independent and free to make the decisions that we think are correct on the merits. So every time that I see students come into the courthouse, I'm really excited to see them, or when judges go out into the community. But that it's important that people understand that the courthouse is that's their house, and that's where they should come in. We used to have court watchers when I was a young lawyer, and it was a group of people that were retired. They would come in, they would watch trials, and then as I would be coming out, they would pull me aside and say, "Hey kid, you know, that cross, I don't think that went over so well." But they would come in and they would sit in the cafeteria and have coffee and talk about the cases and talk about the judges, but more importantly, would go back out into the community and be our advocates and talk about how judges decided cases, and that things ran smoothly, and that things were fair. And that, I think, is so important. And I understand these days that it is harder and harder and harder to get into courthouses. And in some ways it should be, because for judges to be independent and feel like we can make the decisions we need to make, we need to be safe and we need to feel safe. And we have to walk that line between security and safety and keeping the courthouses open, so that people can see what we do. Because if they don't see what we do, they won't understand what we do. And they won't understand how nonpartisan we are. That we are not trying to get to the right result because it will please the president or will please the senator that put our name forward. We want to get to the right result because it's the right result. And the more that the public can see that we do follow norms, that we don't decide cases solely on a particular whim, but that there is a process and that the process is consistent. No matter what judge, no matter whether it's a district court judge, a magistrate judge, a bankruptcy judge, a judge sitting on the Court of Appeals, there is a consistent process, and you can bank on that process. So the more that we have the public understand what we do, the more that they are invested in and understand how fragile judicial independence is, and will stand up for us when it's threatened.
Judge Cole?
Yeah, I think it's important to focus initially on just the three branches and how different they are. So if you look at the executive branch, you're looking at millions of employees who are, federal government employees who work in different agencies, different sectors of the federal government. You look at you got the cabinet, you got all of these, various officials, and we expect for the executive to have policies that they're advancing. We expect the executive to run the government on a day-to-day basis. And we expect the government to be, the executive to be visible in terms of advancing its agenda, its policies. You look at the legislative branch, of course, their job is to enact laws. They also have policies that they're advancing. And we see these daily. So, a good example, I think, just in front of us today is the debt ceiling crisis. So what we're seeing right in front of us right now is the executive and the legislative branches are negotiating, trying to find some sort of agreement where this very important issue can be resolved. Reported in the news daily, and we hear, of movement one way or the other in terms of the policies and positions of these two branches. Notably absent, of course, is the judiciary. We are more reactive. There's no role for us to play right now in terms of this debt ceiling crisis, and there won't be unless and until some sort of action is filed in our, one of our courts. And what I would tell the public is that we are not designed to advance policies in that regard. We are really more of a silent partner, though critical partner in the whole process. And we become more involved, obviously, once some sort of an action is brought to the courts. At that point, our role is to decide cases based upon a record that is made before us. We don't worry about what president appointed us, or we certainly should not. We do not, our decisions are not guided by the party of which we were before we became judges. We review matters based upon the Constitution, based upon the law, and based upon the record that gets made either at the trial court level or that's before the appellate court. So that's what I would tell the public. Our role is just very different from these other two branches, which are very visible in terms of advancing their policies and their perspectives.
And I guess just to follow up on that, I think that it's important for the public to understand that we play the long game and that we look at issues that come before us in the context of history and in the context of how issues have come before us before and how we may expect them to come before us in the future. Whereas, the executive branch or Congress or state legislators are of the moment. And so they may not, as you're drafting a piece of legislation, be thinking about how does this interact with other pieces of legislation? How does this interact with other decisions that have come before? Sometimes it is in the legislator's mind about this interaction, and they will draft things very specifically. But a lot of times they don't. And it's, kind of like making sausage. You throw a bunch of things in there and you see what comes out. But as judges, it's our job to look at particular issues in the context of everything that has come before. And I think that it creates a lot of stability in government where people can rely on precedents. People understand what their rights are, that they believe that once it's established, they're not going to disappear. And that is our role in terms of judicial independence.
It's really a helpful foundation because I think, you know, you laid out a couple of aspects to independence. I think we'll get into each of them. You talked about decisional independence, you know, making decisions in cases free from improper influence. You talked about the independence of the judiciary as a branch within our government, what its role is. And on the last point, Judge Ellis, I hear you talking a little bit about the logic of the law and the way that that promotes independence and the culture of the law. So I want to start with this issue of your decisional independence. This is, you know, Mary Bilder this morning referred to this as this thing called judging and the emergence of this thing called judging. And I was wondering if you could talk a little bit about when you are doing that as judges, what are some of the constraints, the norms, the procedures, the practices that help you ensure your independence, that are part of you staying independent? And I'll start with you this time, Judge Cole.
So I'll use an example that's, you know, in the news now, and so the asylum issue, the border crisis. So, you know, the public, you know, understandably thinks about the immigration issues in a very broad sense. What policy should our country have in terms of people from outside this country entering and obtaining some sort of review of their status in the event they're seeking asylum or some other protection in this country. For the courts, we review those matters on a case-by-case basis. So yeah, there are all these overarching policies, but the courts make decisions based upon records that come before us. So in the immigration context, those records are made by an immigration judge and a board of immigration appeals, and they come, for example, to the Court of Appeals with that record before us. So to the extent a petitioner, as we call them, is making a claim that he or she should not have to return to their country of origin based upon some sort of status, threat, persecution, or something of that nature. We as courts are not looking, you know, really as much at the overarching policy as we're looking at what record have the parties, the government and the petitioning parties made before us, and we make our decision based upon that. Which leads me to the next point, and that's that, you know, courts are governed, you know, by precedent. So, you know, we're not reaching decisions, you know, from whole cloth. You know, we have a long body, usually, not always, of law that gives us guidance in terms of how other courts have decided the matter, how district courts within our districts, how circuit courts within our circuits, and of course the Supreme Court. And so we have that precedent as a guidance, and we're bound, obviously, to follow precedent to a certain extent. The other thing that I think is a guide, I'll just say for the appellate courts, and this has been referenced earlier, you know, the appellate judges sit in panels of 3 ordinarily, and having 2 other judges who hear the matter along with you, and then are in a conference following oral argument, if the matter is argued, to discuss the matter is of great benefit, because it gives certainly me as a judge a chance to hear how 2 other judges have, you know, reviewed the record, how they've assessed oral argument, and how they're looking at the case that is before us. we also have, to the extent the panel has decided a matter in a way that maybe is a little bit off the rails, or somebody views it as being erroneous, there's a process for panel rehearing. There's also a process been referred to earlier for en banc review. And in larger circuits, you're looking at an en banc court of 14, 15, 16 judges. And, that is, a bit of a self-regulating aspect of being in the appellate courts, because I think any judge is at least somewhat mindful of, is this a matter that, might prompt the en banc court to review this? And it's a good thing. I mean, it's good to have the full court there to deal with matters of great importance, of exceptional importance, to the extent the en banc court has a different take from the three-judge panel. And then, of course, you've got the Supreme Court, which can decide to grant review of a matter that they're requested to take.
Jealous about on the district court?
Well, we have the Court of Appeals, and that is a very significant constraint on people going off the rails. And I think it has more to do with people's humanity and sense of self, in that nobody wants to be told that you're wrong. And nobody wants to be publicly shamed and said, you're an idiot and you can't read. So that, I think that actually goes a long way when we were talking about norms, that it does keep people in check, because for the most part, most people don't want that public shaming. And most people care. And, I don't want, and I don't seek to be reversed by the Seventh Circuit when I issue the decisions that I issue. I'm okay with being reversed if I believe that, not everything is black and white. And if there are ways that the Seventh Circuit could say, this is how it should come out, and I could legitimately say, no, I think it's this other way. If it's two equally valid outcomes, I choose one, they choose the other one, there is no shame in being reversed. But where you go completely off the rails, there's a lot of shame in that, and there should be. So I think that is an institutional way of kind of keeping individual decision-making in check.
So there's this culture of the law and remaining within the bounds of the law and following precedent and not getting overruled and not getting told you're an idiot by your colleagues that helps to ensure judicial independence. There's this other aspect of it that came up on the earlier panels. I think Marin Levy referred to it as the family of in-laws, but sort of coming into the court, the culture, the collegiality. And I was wondering if you could each talk a little bit about your experience with that, about how the community of the court and your colleagues shapes your sense of independence, reinforces or bolsters those norms. Start with you, Judge Ellis.
And I think it's true. It is a family, and that when you join the court, that you are joining a family. And I know that across the country, levels of collegiality can vary from court to court and circuit to circuit. But I can say in Chicago, in the Northern District, when somebody comes on, that it's almost a welcoming committee, and people go out of their way to share things as mundane as, here are the spreadsheets I use to keep everything on track so that cases don't fall through the cracks. to every Wednesday morning, we have coffee together. And when you do that over time, you get to see that it really doesn't matter who appointed you, that people have families and dogs and go on vacation and ask for restaurant recommendations, and you get to know people as other people. And what that does is creates, particularly on the district court, when you are deciding things in isolation, that it's a space where it is open and safe to ask questions, that you are not meant to, nor should you believe that you have all the answers, and that things are difficult and hard. And so it might make sense to, over coffee on Wednesday, say, I'm struggling with this, and what do you think? And that you can then talk it through and get other perspectives. The nice thing about being on the appellate court is that you have to convince two other people to agree with you that what the result that you believe is the right result actually is the right result. And not only that it is the right result, but the way you got there is the right way to get there. And as a district court judge, it's important to be able to have those kinds of conversations with your colleagues. But you will only do that if there's trust, if there's mutual respect. And so I think that these things of collegiality are so important to build that.
Judge Cole?
Yeah, I agree completely. The prior panel, made several, really good points on this. The DC Circuit certainly focused under Judge Edwards on improving collegiality, and I think across the circuits there's been, a renewed focus on doing that. With the DC Circuit, you have all of the judges in one location. The challenge for many of the other circuits is that judges are resident in multiple states, and there is usually, a home court where most of the arguments are held, though some circuits do travel. But the challenge is that the judges don't see one another each and every day. You can go weeks or months, 4, 5, 6 months, and not sit with another judge or maybe even see that judge. So it's important to do whatever can be done to enhance the opportunities for those judges to interact. As Judge Ellis said, get to know one another on both a professional level and a personal level. I mean, I agree with Judge Edwards in his article from a number of years ago. Yeah, it's great to be collegial because you want to work well with people and hopefully enjoy their company. But collegiality also promotes an openness for discussion and, again, hopefully respect for one another's positions. So I'll just use the Sixth Circuit as an example, but we're not the only circuit to have done this. We have made collegiality a priority. And so to such end, we've tried to develop opportunities for when we're in our home location in Cincinnati to get together. So there's a summer boat ride with judges and law clerks that gives us a chance to get together socially. We try to have lunch. Most recently, judges and their law clerks. And that way you have a chance for 3 judges to get together and law clerks from those chambers. We have a dinner during the holiday season. We try to sit together as a full court 3 or 4 times a year now, so that we're all in Cincinnati at the same time. I think there's just a real benefit if the judges can really just spend time, get to know one another, maybe get to know one another's families to some extent. It just promotes more productive discussions, more open discussions, and I think at the end of the day, better decision-making.
That's Judge Colt, such a good point about collegiality, that it's not just about all getting along, but it's actually about fostering an environment that's open to ideas. Because one of the things that came up in some of the earlier panels is the reality of increasing polarization and the impact of that increasing polarization on the nomination and confirmation process for judges. And the public sees that. It's very aware of it. We all are. And that sort of structures the whole way that judges come to the bench. And so what do you say to people looking at that and saying, like, look at this? I mean, there's just such increasing polarization. What do you say about how that, how the culture of the judiciary or the culture of your courts helps ensure a kind of robust independence?
Well, I think that as others have said, we're living in a very polarized society. I mean, that's just the reality. I can't estimate or predict now when we will be less polarized. If anything, we seem to be going, in the direction of becoming even more polarized, if that's possible. So I get that question from friends and family and just members of the public. What is it like to work on a court, especially an appellate court, multi-judge court, where you have judges who are nominated by different presidents of various stripes, who these days go through a very difficult and challenging nomination and confirmation process. How do you find a way to work together? And it's like anything, you have to work at it. In our court, when new judges come on, we do things to try to welcome them and to make their move to the courts smoother. We have a mentor judge who will help that judge make the transition, from their prior work to work on the court. And I think we just do our best to follow, the rule of law, to be faithful to the rule of law. Yeah, do we have different tools in our toolkit, so to speak? I've heard that expression before, in terms of how we decide cases and where we end up in terms of the resolution. Yeah, that's definitely true. But I guess my view is that the judges are trying very hard to follow the precedent, whether it's from the Supreme Court, Circuit Court, to abide by constitutional principles and to make the best possible decision they can make. These are challenging times, though, and as a member of the public, if I step back and look at the courts, I would be concerned, especially over the last 3, 4, 5, 6 years. And I just think we have to keep working at it. Some of the things we do, again, across the circuits to try to help with this is address the issues that are of real concern to the public. Workplace conduct. There has been a real focus the last several years, thanks to the Chief Justice and others, for the courts to focus on problems that arose within the courts that can get exacerbated because of differences that the judges and others have about issues. And so we're addressing those kind of issues, and most courts have a directive workplace relations. We're also focusing on things like wellness. And to the extent there are issues that divide courts or cause problems that seem to be related to some sort of disagreement and misunderstanding, sometimes those are issues that are based upon health reasons or reasons related to health. And so there are avenues which judges can access at this point to get assistance. And then, of course, there are provisions to deal with judges' conduct and disability. And I think the courts are being very mindful to ensure that those sort of issues are addressed. At the end of the day, we have to continue to earn the public's trust. And we can only do that by ensuring that we are governing ourselves in a manner that is appropriate, and that we're, again, just doing the best we can to follow the law.
Alice?
Yeah, I completely agree. I mean, it is incumbent on judges to keep our own houses in order, or our own house in order, and to be proactive about it and not wait for decision issues to come to us, but that, we're not waiting for the next Wall Street Journal article to be published, but that we are taking an active role in looking at ourselves, looking at issues that bubble up, and then dealing with them in a very timely and proactive basis. I think, though, that we can also look to the other branches of government for assistance too. How do we select judges? So that the more that we can rely on merit selection panels, that will give the public trust that people are not being chosen on a partisan or ideological basis, but instead that by the time a list of finalists gets to a particular senator or two senators, that they have been vetted through a nonpartisan committee who is looking at people's experience, who that committee, when they are looking at particular applicants, that they focus on a diversity of applicants, right? So that you are looking at people that aren't just coming from big firms or aren't just coming from the US Attorney's Office, but are coming from a variety of experiences, a variety of backgrounds. And then the senator commits, here's the slate. We'll put someone from this slate before the president for nomination. I think that will engender trust in the public that people are not being chosen on an ideological basis, but rather on the basis of their work, their career, their merit. Then, when we look at how the courts administer themselves, that we really focus on random assignment of cases and that they are random. So that the more that the public believes that they cannot judge shop. So you cannot bring a case in a particular district and think that you are only going to get that particular judge and it's only going to go to that circuit. You can't stop people from filing things in a circuit. But if there is truly random selection, people can't judge shop. And that, I think, will also go towards creating this sense that there isn't necessarily this partisan ideological nature of, I'm going to choose this judge because I know I'm going to get this result. I think that too is really important. And, just a plug for diversity is, I know we've talked about precedents, and I don't want anybody to think that we are chained to precedent because the law does change over time and should, because society evolves and changes over time. And I think one of the best examples of that is when you look at the evolution of sexual harassment cases in employment law, that when the bench was mostly male or all male, that it was very difficult to prove sexual harassment cases, because the people that were deciding those cases would look at the facts and say, you know, this is just part of the job, right? Seeing photographs of naked women plastered all over the inside of a locker and having comments as you walk through the break room, you know, you should expect that. That's not harassment. Shouldn't bother you. That doesn't impact your ability to do your job. Then the more that you had women coming on the bench, those women were able to reflect on their own experiences and say, you know what, actually, that does impact how I do my job. And that does make it difficult every day to go to work. And the law changed, as it should. So I don't want anybody to think that, you know, just because something has been decided one way, that it should always be that way. That is not judicial independence either, right? I think judicial independence comes down to seeing how society has evolved, how norms have changed, and being able to look and see, should the law also then change to go along with how society views certain conduct or behavior or actions.
Which really goes back to something on one of the earlier panelists mentioned about, you know, one of the things that lifetime tenure promotes is the ability to develop the expertise and the deep thought and understanding in the law to be able to make decisions about it. And that's an important part of judicial independence as well. So we've talked about sort of the decisional independence. We've talked a bit about the logic of the law. And there's a third aspect that I wanted to ask you a little bit more about, which is about the branch as a whole. And we heard on the earlier panels about the growth of the judiciary since the founding, but then of course the development and the buildup of kind of administrative apparatus for the courts and for the branch as a whole, largely in the 20th century. And I wonder if you could both speak to your sense of your role within the branch and your sense of the relationship between the larger administrative apparatus, the branch as a whole, and your particular role as a judge. I'll start with you, Judge Cole.
Yeah, I think we're very fortunate actually to have the expansion that has occurred over the last 40 or 50 years or so. I mean, we have the Administrative Office of the Courts, which I think employs somewhere around 800,000 people with various degrees of expertise as to all kinds of issues that impact the courts. And that would include ethics. So to the extent a judge has a question about ethics, that judge can call the administrative office and talk with someone who has experience. We have the FJC, the Federal Judicial Center, and we have opportunities like this one to learn more about subject matters and issues that impact how we, do our job. So I think that the expansion of the administrative apparatus overall has been a good thing. We get more information, look at the law clerk hiring process. Now we have this Oscar, which allows us to have exposure to a wide range of law clerks, gives us a chance to review, on a database essentially that will set forth the application materials for those candidates who are interested in clerking. And for me, for example, I'm looking for a diversity of law clerks in every respect, including clerks who will come into my chambers and give me perspectives that I might not otherwise hear. I always ask for at least one clerk to take the position that's contrary, perhaps, to the position that I have, and to argue that zealously. So anyway, I think the administrative structure is a good one. Again, as I mentioned before, with that, there is the opportunity for any member of the public who has a complaint about a judge or judge's conduct or judge's ability to serve. That person can file a complaint, and there is a very robust review process throughout the circuit council, the judicial conference, perhaps, to review whether that judge is suitable to continue serving. And of course, there's always the process of impeachment if grounds exist.
Jealous?
Yeah, I think that the expansion of the administrative aspect of the judiciary has really helped in terms of judicial independence, in that we are then able to show the other branches of government that we can manage ourselves. And I think it's also helpful for judges to participate in the judicial conferences, different committees, and show that we're able to kind of manage how the courts run themselves, how also the different agencies that work with the courts, how those are run. And it brings up different things for judges to think about. So for instance, I serve on the Defender Services Committee, and through that work, hear about different constitutional issues that bubble up across the country that we then, as a committee, need to deal with in terms of, do defendants, are they being represented at all critical stages of the proceedings? You want the answer to be yes, right? But there may be different courts across the country that have different practices or different cultures or different understanding of how they do things. But as a judge myself, when I'm looking at my own cases, it helps bring some of those issues to the forefront so that I make sure that I am being careful with all of these issues. So I think that it also fosters this sense of ownership in the judiciary when we are working on committee work or with the FJC or working with the AO or other agencies, that this is our branch and we take care of it and we have pride in it and we understand how fragile judicial independence is and what we need to do to take care of it and make sure that it goes forward. As people have said before, that this is a family, and sometimes, a family of in-laws, that yes, we can criticize each other within the branch. I can talk about my sister and say horrible things about my sister, but God forbid anybody else say anything horrible about my sister. So it does create that sense of ownership in the judiciary, that this is our career. this is our calling. This is our branch and we need to take care of it. So I think that that also strengthens this concept of judicial independence, is when you are vested and you care about it and you want to maintain it.
So a lot of our conversation to this point has already touched on a number of sort of current issues or touched on sort of our social and political climate at the moment in which you're operating. And I just want to ask you about that more directly. Is just sort of, what do you think, what are the big issues? What's on your mind about judicial independence in this current social and political climate? How do you see the significant issues? And I'll start with you, Judge Cole.
We live in difficult times. I think it's a tough time in some respects to be a member of the bench, but I think it's tough for the public too. And that's why I think, as Judge Ellis said, focusing on civics and the education of the public generally is just very important. I mean, we've got a 24/7 news cycle. And I encourage, public discourse, political discourse, public discussion, and disagreement with what this branch does, what I do as a judge. That's part of our constitutional framework. And so I am not at all opposed to that. But you look at just the various threats that exist to independence of our branch, and we just have to find ways, excuse me, to address those in a productive way. All we can do is decide cases. We find facts, we interpret the law, we write opinions, and then that's really the final word from us until a reviewing court reviews it. At the same time, with social media, with all the cable shows, the talk shows and pundits who in 30-second sound bites are giving their thoughts on the correctness of our decisions, the wisdom of our decisions, the thoroughness of our decisions, we are powerless in many respects ourselves to address those. So it's important for us to be transparent. It's important for us to urge parties and people generally to come to our court proceedings. A lot of the circuits now are streaming oral argument, and you can stream right off of YouTube. And I know in our circuit, and I think most of the circuits. Add to that, just the increasing number of threats that judges are dealing with. And of course, we've had several very unfortunate incidents where their threats have been taken to actual devastating action. All these threaten, our independence as a branch. But hopefully there are groups that can help explain what we do, bar associations, educational arms like the FJC, and people who understand what we do as judges, so the public can come to understand better what we're doing, behind those walls of our chambers or in the courtrooms. I would imagine it could seem quite mysterious to a member of the public, especially for a court of appeals, where you've got a very brief oral argument, and the public doesn't know how, these three judges are coming to a decision and what goes into the process. As others have said, most decisions are unanimous, like over 90%. And most discussions among three judges are very productive. I will say, as someone said earlier, I think the en banc court is a bigger challenge because you're dealing with a larger number of people. But again, I think as long as we are very clear and I guess just proactive in informing the public that self-governance is a priority in our system of and in our branch, and that we are doing our best to address the issues that would be of concern to any member of the public or to us. That's a good thing.
Judge Allison?
I think what I worry most about is creep. So I don't know that we're going to lose judicial independence in one fell swoop. I don't think it's going to be something that happens from one day to the next and it's over. I think it's more that it would erode. And without vigilance, that is what would happen. That there would be enough issues that bubble to the surface where all of a sudden there's an inspector general that is appointed by Congress, or various legislation is passed by Congress that then kind of eats away at judicial independence. So I just worry about judges not being vigilant enough and looking at the threats to judicial independence that come across the board. And when we talk about security and safety, for example, that maybe we get too far on the side of security and safety, and then courts are no longer accessible the way that they need to be. So, I think that it is always a balance, and we have to just always be thinking about these different things, not in a vacuum, but how they all fit together. But what we can do is we have a voice. That voice is in our opinions. And the more that we can write clearly and directly, that the public can read our opinions and understand how we got to the decision that we did and follow the line of our reasoning. And it is something that's clear and doesn't come across as partisan, that we are measured in our writing, that we don't take pot shots at the parties, or we don't take pot shots at the judge or judges on a panel, that the more that we can be measured in our writing and clear in our writing and transparent in our writing, that too will help protect. And that's what we can do. That's our voice.
It makes me think of the point Larsen made this morning about these norms didn't emerge in one fell swoop, right? They were built up over time, and if they're going to be lost, won't all be in one fell swoop, but an erosion of them. Well, we've covered a lot of ground in a few short hours this morning, moving from Madison and the framers all the way through the 20th century up to our conversation with judges today. Very different contexts from Madison's time to talking about the judicial branch as it is today. And you and your many colleagues, an entire institutional apparatus around you. What is clear, though, is overall that time, people have thought deeply about judicial independence and what it means, just as you all are and as our speakers have today. And certainly that will continue. I want to thank you both so much for your generosity with your time this morning. Thank all of our panelists and the audience for being with us today. It's been really enriching, and thank you.
Thank you.